Workers' compensation legislation in New South Wales. So, workers' compensation hinges upon reasonable and necessary. Bear in mind, every time that money is spent on workers' compensation and injured workers, it uses the insurance money, and the insurance money uses government money, and government money uses your money because taxpayer pays the government. Of course, when we start to look at injured workers, we would need to look into the treatment of these workers first. And we ask the questions such as, is it reasonable to return to work for the injured worker? And is it reasonable for them to get back to a normal life? Other questions include, is it viable to job seek for the injured worker? Do they have a cultural or language barrier? Are they too old to job seek? Because, for example, if they're one day away from retirement, then there's no point on setting the goal to be returned to work. Other things to consider include determine the function of the treatment. So, for instance, will the injured worker be healthy as a result of their surgery? Treatment depends upon evidence-based medicine. And to decipher whether something is evidence-based medicine depends upon discussing the viability of treatment and or training. The insurance would then be willing to begin to discuss these and approve funding if they think it's viable and if it's reasonable and if it's necessary. Is it reasonable? The insurance will always time and again ask, is this reasonable? But the problem with this question is that it can be quite qualitative, or rather it could be quite subjective, where one's opinion conflicts against another's opinion of whether a thing is considered reasonable. And other questions include what is probable and what is possible, because what is possible and what is probable are two different things. If someone is willing to employ an injured worker, then that is considered reasonable in regards to getting treatment, undergoing training, and or returning to work. Also, according to WorkCover, pain is not fundable under the legislation because pain is subjective or psychosomatic. It's not really an objective thing. Anyone could say that they're in heaps of pain. Thus, what is reasonable and what is necessary is dependent upon what the experts say. And the experts include the nominated treating doctor. They include the nominated treating specialists, the nominated treating physiotherapist, the nominated treating psychologist, the nominated treating psychiatrist. All of these healthcare specialists and professionals are the ones that help to build up the case and say that, yes, this treatment or this training or this whatever program is reasonable and necessary. Thus, as a result, rehab providers or the workers themselves, they can't exactly say what is reasonable and necessary on their own terms. They can only choose things that are within the range that is reasonable and necessary as according to the health professional's advice. The rehab provider's role is to meet within what is reasonable and necessary. If we cannot meet within it, then we will consult with all the relevant stakeholders, with the nominated treating doctor, and all the other nominated treating health professionals to help build up this case of what is reasonable and necessary. Thus, it is our job as a rehab provider to coordinate stakeholders to organize what is reasonable and necessary. A matter of ownership. If WorkCover pays the recommended item, such as maybe a cleaning service or a wheelchair or any certain activity of daily living equipment, it implies that the object or service is owned by them because they are the ones that paid for it. Thus, as a result, WorkCover cannot fund things for the employer because the employer does not own the recommended item. So they'll ask the employer to buy the ergonomic chair or whatnot, and WorkCover will not pay for it because the employer owns the item then. If WorkCover pays for it, then WorkCover owns it. The bad thing though for employers after an injured worker returns to work is that the premiums increase. This, however, needs to be noted that it's different to CTP claims are different to workers' compensation claims. Bear in mind, it is also in the employer's interest to increase working capacity because, well, then they could get their workers to work more hours and the workers themselves can recover at work. Now, I need to talk about the difference between IMEs and IMCs. IMEs are independent medical examinations. The purpose of an IME is to determine liability, to prove whether their injury or lesion or psychological issue is what the nominated treating doctor says it is. This includes deciphering the mechanism of injuries, or also known as the frame of incident, and it determines such as wear and tear, slips, trips, falls, how the injury was caused, how it came about. It then also decides whether it was reasonable that this injury had occurred from the said cause. After an IME has determined that the injury is resolved, then the insurance is no longer entitled to pay any workers' compensation benefits. So as a result, the IME is used to deduce liability, to deduce whether this problem is actually a problem and what is the cause of the problem. And then as a result, the outcome would be to give further treatment and compensation benefits if the problem is said to be a problem. Next is an IMC. An IMC is an independent medical consultation. IMEs, I should have mentioned before, depends on a panel of specialists and doctors and experts, whereas IMCs is not really about determining liability. IMCs are about determining capacity to work. What is an individual's functional capacity? If they have some functional capacity, then that implies that the insurance does not have to pay a certain amount or benefits because they have already some capacity. As of the 2012 Act of Section 78, IMC and not IMEs are involved in functional capacity assessments or working capacity assessments. Stage 1 of the IMC is to have a medical review and to speak to the case manager. Stage 2 of the IMC is to review the information on file and to discuss this with the nominated treating doctor. And then stage 3 is to see the client as well. The doctor has 10 days to respond. When the 11th day arrives, the IMC is stated if found to have working capacity, and thus as a result their capacity increases. A Section 74 notice is a written decision from the insurer that declines the claim for either weekly compensation or medical expenses or both. In retrospect, it would be better to gradually reduce the payment amount than outright decline the claim, because the workers themselves are dependent upon that amount of money, and suddenly cutting it out of their lives may cause, of course, extreme visceral reactions. It is also important to mention that reducing the amount creates motivation and incentive for the injured workers to return to work if found to have capacity. Work cover will always favor return to work over declined claims. Thus, the insurance is required by law to carry out capacity assessments, and they need to carry these out every time there is a change in information. As rehabilitation providers, we work with the stakeholders, and we would not be so rash to change the plans and decisions on a whim. As a result, we work with the various stakeholders such as the doctors, the psychologists, the employers, the insurance, case managers, so on and so forth, to seek evidence of capacity. Everything we do, such as worksite visits, rehabilitation counseling, etc., help to build up our case in seeing whether someone has working capacity, and thus increasing the working capacity as a result. It also depends on our own professional observations as healthcare providers, as allied health professionals, to see how the individual behaves, how they dress, how they appear, whether they're punctual. Things like that help to build up our case to show, yes, they are motivated, or they have the right mindset, or they are recovering from their treatment and thus ready to begin the return to work process with their same or different employers. So yeah, that's the legislation, which is discussed very briefly in a nutshell anyway. Of course, there is quite a lot to sort out, to read through in the legislation, and I would encourage you to do so. Thank you. Bye-bye.